to the leases era. That's right. In the next half hour, I'm going to combine a talk about liquidators and insolvent company property with the theme of the singer-songwriter sensation that is Taylor Swift. In fact, the law surrounding insolvent company property is vast and complex. So I've narrowed this talk down to the context of leases and company liquidation. The law regarding the property of insolvent individuals in bankruptcy is broadly similar, but there are different rules regarding CBAs and administration. But while I've focused on liquidators, it's important to bear in mind that when we're dealing with insolvency and also a property context, there are many other parties who will have an interest in what's going on. So we're dealing with an insolvent company. There'll be a liquidator, there'll be creditors. The lease element that I'm going to talk about brings in a landlord, a sub-tenant, a guarantor, maybe a mortgagee. So any step taken by a liquidator that I talk about will have a knock-on effect for those other parties. So even if you're advising someone else, hopefully this talk will help you appreciate how the various different interests sort of knit together. When I was preparing this talk, I thought about some of the key concepts that underpin the principles that I'm going to talk about. And I just wanted to highlight a few of those now, particularly for anyone in the room who doesn't practice in insolvency primarily. So first we have the liquidator. Her primary function is to collect in the company's assets, realize them, and then distribute the proceeds to the company's creditors. And the liquidator has a collection of different powers in order to achieve that. Then we have creditors. The collective interests of the body of creditors are paramount in insolvency proceedings, and the liquidator's actions will largely be informed by the interests of those creditors. Then we've got a lease. Well, a lease is both an asset and a liability. It's a collection of reciprocal rights and obligations. So on the one hand, the tenant has a liability to pay money and to perform certain acts, like keeping the property in repair. And the landlord has a corresponding right to receive that money or the benefits. The lease is an interest in land, which comes with a right to possession. And in that way, we can talk about it as being an asset with value, and that value can be realized through sale. It will depend, that the value will depend, I suppose, on the market at the time, the rent, how onerous the repairing obligations are. It's also worth bearing in mind that while we're talking about the liquidator's powers, in and around all of this, the landlord still has her own remedies. So forfeiture, for example, that right continues to exist. And this talk touches on two mechanisms to determine a lease. One of those is forfeiture, and the other is disclaimer. The effects of both are a little different, as we'll see, but both concepts come with this power to revive a lease that, for other purposes, has been determined. Forfeiture comes with the ability to seek relief from forfeiture, and disclaimer comes with an ability to apply for a vesting order, which I'll talk more about in a moment. So this is where we start. At the time of liquidation, we need to ask, is the company a tenant under a lease? A liquidator can look backwards at transactions that a company entered into prior to liquidation. So it may be that a company had a lease, but on finding itself in financial difficulty, the company disposed of it as a way of raising money or as avoiding further liabilities accruing. And as part of the liquidator's function in collecting in the asset, she can look and interrogate antecedent transactions. So if there's been a prior disposal, you need to consider whether there are grounds to attack that. A disposal could be by way of a surrender, an assignment, maybe a grant of a mortgage, or a grant of a sub-tenancy. Consider if the formalities were complied with. Now that's particularly relevant in the case of a surrender or an assignment. What about if the person executing the document had authority to do so? And if they were a company director, was there a conflict of interest, for example, that might have put them in breach of their director's duties? And then you'd also consider whether the disposal could have been a TUV, a preference, a transaction defrauding creditors, or a void disposition. Now, if you succeed on one of those applications, the effect may be that the leasehold interest is restored into the assets of the company. If the company does hold a lease at the time of liquidation, or that lease is restored to the company's assets, then liquidation itself doesn't terminate the lease. It may well be a ground for termination, but not necessarily. And that means that although this seismic event has happened to the company and that it's entered into liquidation, the lease and all the obligations contained within that is still ticking along in the background. So one of the first things that a liquidator will need to decide is whether or not to retain the lease. And that's a question of discretion for the liquidator. The main reason a liquidator would want to retain a lease is because there's value in the lease and she wants to market and sell the property, thereby increasing the company's assets and the benefit to creditors. Now, the liquidator does have a statutory power of sale, but the exercise of that power will be subject to the terms of the lease. So the ability of the liquidator to actually dispose of the lease by an assignment, which obviously you need to transfer the lease, may be prohibited or may require landlord's consent. A much less common reason to retain the lease is because the company has something like plant or machinery that's stored on leased premises that the liquidator wants to leave in situ while she's finding a purchaser for it. And this is a very niche scenario, but there's quite a lot of case law on it because the purpose of the retention is really important. Just storing goods on the premises isn't sufficient. The purpose has to achieve some benefit for the liquidation. So let's say the liquidator does wish to retain the lease because she wants to sell it and increase the company's assets. Well, what is the landlord going to make of that? At the point of liquidation, there are quite possibly rent arrears that have accrued up until liquidation. And then because the lease continues, there's ongoing rent, which will continue to fall due. And the liability for those elements is different. And to understand it, we need to consider the difference between liquidation expenses and debts that are provable in the liquidation. Liquidation expenses are fees, costs, charges, other expenses that are incurred in the course of a winding up and are treated as expenses, therefore, of the winding up. And importantly, they are paid first out of the company's available assets. So they're paid ahead of unsecured creditor claims. Provable debts, on the other hand, are paid out of the company's pot of assets that's available after payment of expenses, in accordance with the pari passu principle. So all creditors in the same class rank equally. But remember here that there will likely be insufficient assets available for the creditor's provable debt to be paid in full. Where a liquidator adopts a pre-liquidation contract, which could include a lease, for the beneficial conduct of the liquidation, all the liabilities which arise under the contract after the date of adoption are entitled to priority payment as expenses of the liquidation. Now, this is called the Lundy Granite Principle, and I'm afraid that even the sparkle of Taylor Swift can't make that sound any more interesting. It's also known as the salvage principle or the liquidation expenses principle, but frankly, those aren't much better. Obviously, the lease and its liabilities precede the liquidation. It's not a contract that the liquidator themselves entered into, but the principle works basically as a deeming provision. So the liquidator is deemed to have incurred the liability for the benefit of the winding up. And what underlies this, going back to my initial themes, is that the body of creditors are taken to have benefited from the property being used by the liquidator to perform her functions in getting in the company's assets. What then of the rent arrears that have accrued at the time of liquidation? Well, the landlord has to prove for those as a debt in the liquidation. And also, in circumstances where the lease continues, but the rent isn't payable as an expense, so for where the lease is retained but not for the benefits of the liquidation, then the landlord can prove for those installments as well. That is obviously a much less desirable position to be in, because you're in the mix with all the other unsecured creditors. Behind all of this, a landlord can still forfeit a lease that continues post-insolvency, but I'm just flagging up that the right to do so is subject not only to the usual restrictions of the Law of Property Act 1925, so Section 146 notice, if necessary, but also Section 130 of the Insolvency Act, which would prevent a landlord commencing or continuing with proceedings without leave of the court. So there's an extra hurdle for them to have to go through. But you could end up in a situation where the landlord forfeits the lease early on in liquidation on the ground of rent arrears. The liquidator would then have to apply for relief from forfeiture to revive the lease by paying off the arrears, most likely. And then the liquidator can retain the property for a short time to sell the assets being stored there or sell the leasehold interest. So that is an overview of what happens if the lease is retained, even for a short time. A disclaimer is not the only option if a liquidator wants to retain a lease. She can, in theory, just sit back, not pay rent, and allow the landlord to forfeit. Or she could seek to surrender the tenancy. But a liquidator does have a statutory power to disclaim onerous property. And the effect of that is to determine an insolvent estate's ongoing rights, interests, and liabilities in the property disclaimed. The most common asset that is disclaimed is leasehold property, and particularly this would be a lease with a rent that's above the open market level, because no one's going to want to buy it, and the ongoing liabilities are just going to deplete the assets available to creditors. Onerous property is a key concept. And in addition to leasehold property, it can include unprofitable contracts, shares, contracts to create or dispose of land, and freehold property. So if I may go off on a short tangent, this may arise where you have an insolvent landlord, and when freehold land is disclaimed, the freehold interest is determined and the property escheats to the Crown, which just basically means it reverts to the Crown. And then the Crown itself has a power to disclaim freehold land. And if it does so, the freehold title is extinguished. It would be remiss of me in a talk about disclaimer not to mention the case of Smilla Properties Limited against Gesso Properties BVI, which involved disclaimer of freehold land. But I would actually recommend reading this because the judgment gives a really interesting review and discussion about the feudal system and the origins of English land law. So anyway, back to onerous property. The critical feature of it is that performance of future obligations will prejudice the liquidator's obligation to realize the company's property and pay a dividend to creditors within a reasonable time. How is the right to disclaim exercised? Well, simply by service of a notice of disclaimer. When we're dealing with leasehold property, the notice has to be served on various persons, and really it's anybody who claims an interest in the disclaimed property or is under a liability in relation to it, which hasn't been discharged by the disclaimer. Generally here, you err on the side of caution and you send a notice to anybody who could conceivably have an interest in the property. The disclaimer will take effect after 14 days of service if no application is made for a vesting order. If there is such an application, then it will take effect when the court directs that it will take effect. So I'm just flagging that up because we'll come back to revisit that 14-day period later. In terms of timing, the liquidator can disclaim at any time. And that might be frustrating for a landlord who wants to relet the premises and wants to know what the liquidator is going to do with it. So there is a mechanism for a person who's interested in disclaimable property to force the liquidator to decide. And that's done by serving a notice on the liquidator. Service of that notice then gives the liquidator 28 days to decide what to do, and if necessary, serve a notice of intention to disclaim. And if they don't serve a notice, then the right to disclaim is lost at that point. In that situation, the lease would continue, And if it's not being retained for the benefit of the liquidation, then the liquidator isn't paying any rent. So the landlord will likely look to exercise its own remedies and forfeit the lease. Just note that up until now, unless an extension of time is sought by the liquidator to extend the time to respond to the notice, the court has no involvement with this process. This all takes place outside of court. As to the effects of disclaimer, which I think is really the interesting bit, the key case is Hindcastle Limited against Barbara Attenborough Associates Limited. More essential reading, because the court looked overall at whether third parties remained liable for non-payment of rent and other charges under a lease once the lease had been terminated. And the court goes through every category of third party and explains what their position is following disclaimer. So I'm just going to summarize this. At the level of the insolvent tenant, things are quite straightforward. The effect of disclaimer of the leasehold is to determine from the date of disclaimer the rights, interests, and liabilities of the company in the disclaimed property. So that means the disclaimer will determine all of the tenant's obligations under the tenant's covenants of the lease, all his rights under the landlord's covenants, any rights and obligations between the insolvent tenant and a sub-tenant are also extinguished. The tenant's interest in the property, so the leasehold estate, technically ceases to exist, and the tenant therefore loses its entitlement to possession, and if it stays in occupation of the property, it will be a trespasser. Fine. But where things get tricky is if we look at the effect of disclaimer on third parties. And actually, frankly, at this point, the liquidator isn't interested anymore. The liquidator has come out of the picture because of the operation of the disclaimer. The Act says that disclaimer does not, except so far as necessary for the purposes of releasing the company from liability, affect the rights or liabilities of any other person. So what this means is, while the lease held by the insolvent tenant is ended between the tenant and the landlord, these other interests of a subtenant, a guarantor, a mortgagee of the lease, interests that derive from the lease, they continue. So from the perspective of a third party, the lease still does continue. And that is odd. That is very odd. Does the lease exist? Doesn't it exist? If it's extinguished between the landlord and the tenant, surely that is endgame. Because the key to understanding this is that the statute takes effect as a deeming provision. The disclaimer operates to determine the interest of the tenant, but the rights and liabilities of other parties are deemed to continue. So we can still talk about the lease continuing after disclaimer as regards third parties. So it's a spoiler alert, a lease will continue in this limited way until it's brought to an end, and that's usually by forfeiture. The effect of disclaimer on the landlord is that she becomes immediately entitled to possession of the property. And if the property is empty, that means the landlord will be on the hook to pay business rates, which is a consideration. However, there's no obligation to retake possession of the property. And probably what the landlord does will be dictated by whether or not there are third-party interests. In particular, is there a subtenant? If there is a subtenant, there is no direct contractual relationship between the landlord and the subtenant. Nevertheless, the subtenant's interest in the property survives disclaimer, and the subtenant continues to be entitled to possession of the property so long as the lease continues, i.e., so long as it isn't forfeited. However, if you think about it, it would be really unfair on the landlord that the subtenant can remain in occupation of the property on totally different terms to what the landlord agreed with its tenant, the insolvent party, who's now fallen out the picture. So as a result, what happens is the subtenant, in effect, becomes subject to the same terms and obligations that were in the disclaimed lease. And if the subtenant wants to prevent the landlord from forfeiting, Even though the covenants in the head lease, the disclaimed lease, aren't enforceable as between the landlord and subtenant, because there's no privity of contract, the subtenant's going to have to continue paying the rent. In those circumstances, a landlord may be very keen to keep the subtenant in the property, especially if it would be difficult to re-let it. But if the subtenant doesn't comply with the terms of the disclaimed lease, then the landlord can forfeit, and the subtenant would have to apply for relief from forfeiture if they want to stay. The effect of doing that, so a successful application for relief, would be to put the landlord and subtenant in a direct relationship. And it's only then that the landlord could pursue the subtenant directly for breaches of covenant, because it's only at this point there's a direct contractual relationship between the landlord and the former subtenant. If there's a guarantor, so someone guaranteeing the payment of rent of the original tenant, the obligations of the guarantor to the landlord are unaffected by disclaimer as long as the lease continues. So the landlord can still pursue the guarantor. And again, it may be better for the landlord to do that, to rely on the guarantee rather than trying to relet the property. In the case of a mortgagee of the disclaimed lease, the mortgage continues to exist, but it's vulnerable to being extinguished if the landlord takes possession of the property. So the mortgagee's in a pretty dire position, really, because their interest could hang on a subtenant performing the now disclaimed lease covenants. So if the subtenant is in breach and the landlord forfeits, the mortgagee will lose her interest in the property. A landlord has to be really careful after disclaimer not to forfeit inadvertently and lose some of these benefits that she might have if the lease continues. Because forfeiture has the effect of ending not only the tenant's lease, that's here has already been disclaimed, but any interest that's derived from the forfeited leasehold interest. So that means on forfeiture, a subtenant on a mortgage or a mortgagee will lose their interest, and the landlord will lose her ability to rely on the guarantee. So how do we bring this untethered state of affairs back into something more structured and more safe from the point of view of a third party? What is our getaway car from the chaos? Well, the answer is a vesting order. This vests the disclaimed property in another person. In effect, a vesting order is a court-imposed assignment of the original lease, the now disclaimed lease, to another party. Any person who claims an interest in the disclaimed property and any person who's under a liability in respect of it can apply for a vesting order. So a landlord, an assignee of the original tenant, guarantor, subtenant, mortgagee. An application for a vesting order, though, has to be made within 3 months of the applicant becoming aware of the disclaimer or receiving a copy of the notice, whichever is earlier. The court does have a power to extend that 3-month time limit. So in principle, you could get an application for a vesting order 6 months after the disclaimer of the property, if permission's granted. Now, remember, I flagged earlier that disclaimer takes effect within 14 days unless an application for a vesting order is made within that time. So you could have a situation where a notice to disclaim is served on a Monday. On the Friday, someone applies for a vesting order. The lease will then remain alive, for want of a better word. There'll be a hearing of the application for a vesting order, and the court will then grant the order vesting the lease in X. The court then gives directions regarding the disclaimer, whereby the insolvent company's interest will be terminated. So that's how it would work in the first instance, fine. But equally, you could have a situation where a notice to disclaim is served, there's no application for a vesting order within 14 days, so the disclaimer takes effect, and the lease between the tenant and the landlord is terminated. 6 months later, someone applies for a vesting order and is granted permission to apply out of time. Well, what happens in that case, similar to the sort of notion in relief from forfeiture, the lease is revived and then it can be vested in the applicant. An entitled party may apply to have the lease vested in themselves, so a subtenant might want the lease vested in it so that it can enforce a repairing covenant against the landlord. But alternatively, an applicant can apply for the property to be vested in another person. So a landlord might apply to have the property vested in a mortgagee. Why? Well, because there's a statutory order of priority under Section 182 of the Insolvency Act, and the landlord is at the bottom of the heap. So the landlord may wish to put the mortgagee to election as to whether or not they wish to take a new lease. No one can be compelled to accept a vesting order, but if they decline, their interest in the property is excluded. So in this situation, if the mortgagee declined, then the landlord steps up in the list of priority. So while with disclaimer, the rights and liabilities of third parties are deemed to continue, on the other hand, when a vesting order is made in one party, and any other party who'd been entitled to apply, who was offered an order, but who declined it, will lose their interest in the disclaimed property. So I suppose a way of thinking about it is the vesting order doesn't erase the disclaimer. It doesn't operate so as to make it seem that the disclaimer never happened. The position doesn't just revert to what happened beforehand. It's sort of an opportunity to rejig the various rights and interests in the disclaimed property. Finally, in terms of the terms of the vesting order, these are prescribed by statutes. The timing is the significant point here. So either the person is subject to the same liabilities and obligations that they would have been subject to if the lease had been assigned to them just before winding up. So this isn't very common, because what this means is the applicant who receives a vesting order would be on the hook for past breaches of the lease. And that's not very fair to the landlord, because then they're losing their remedy to have, say, the rent arrears remedied. So the alternative, which is more commonly used, is that the person is subject to the same liabilities and obligations the insolvent tenant was under at the time of the winding up. So the applicant picks up the liabilities for any breach of covenant that predated the vesting order. Really what that means is the applicant will have to be ready to pick up the tab for rent arrears, because if they don't, the landlord can then just swoop in and forfeit the lease. Just a final point is that as an alternative to a vesting order, a person who suffers loss or damage by reason of the disclaimer is deemed to be a creditor of the company, and so they can also prove in the liquidation for their loss. But so for example, a landlord who's lost rent, or a subtenant who's had to pay a higher rent in order to keep the lease from being forfeited. But then again, that puts them in the pool with all the other unsecured creditors, and their claim may amount to very little.